To order. Certainly welcome each and every one of you to attend this meeting with us today. At this time, if you would, I'd like to ask you to rise for the say the Pledge of Allegiance. The flag's over my right shoulder. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. This time, I'd like to ask the clerk to call the roll.
Senator Carpenter, Senator Caslin, Senator Embry, Senator Harper Angel, Senator Schickel, Senator Southworth, Senator Turner, Senator Webb, Senator Westerfield, Senator Wheeler, and Chair Smith.
Here. We have a quorum? Okay, we do not have a quorum, but that's okay. We have a few things, some housekeeping measures that we can go over with while we're waiting for some of the members to get down here. Senator Caslin has informed me that he has a special guest he'd like to recognize, so I'll yield to Senator Caslin.
Sure. Today I have a special guest that will be a familiar face around here next year. Gary Boswell, who's in the room today, will be taking my place. He is running unopposed for the 8th Senate District, and he's here joining us today.
You're welcome to our committee. Do I have any other members that have any guests or have any special comments before we start? Senator Wheeler, did you have a comment? No, okay, very good. All right, last week in our meeting was not exactly how we had planned, so I wanted to try to address that this morning about how we handle some of the procedure in this committee, so if you'll allow me. When you want to speak in front of our committee, we ask that you please use the sign-in sheet at the podium, and if you'd like to speak on a bill and the signs are not permitted in the committee room, hold on here, this doesn't make sense to me. So you can do the sign-in sheet at the podium, and if you'd like to speak on a bill and signs are not permitted in the committee room. Yeah.
Just some of the rules that they ask us from the
Just to clear, if you want to speak, we want you to participate, and I want you to be able to sign up when you come in. We had some issues with the emails, and this is sometimes part of the problems when everybody wants to try to do it all down in these documents, and it gets confusing, and we do not want that to happen. I want you to be able to participate. If members have got guests that want to come, so sign in at the podium, make sure you're down there. If something happens and for some reason you don't think you're going to speak and you do get a chance to, let me know, text me, because I do want you to participate in this meeting. And what happened last week was we did not have anybody down. And so I let the meeting run longer because I wanted my members to be able to ask all the questions that they could on this important bill. Unfortunately, we had a group that wanted to speak. And so that's why we're having this meeting today, to make sure that they have the equal time to be able to come and speak on this issue that's important to them, because in the end, it's all about Kentucky and making sure that we have the best information to make a decision on any legislation that passes here. So I appreciate everybody's patience on this, and that's what we're going to try to do today to finish that out so that my members have the best information and that the people in Kentucky have, and people on both sides of this issue have a fair chance to come here and express their concerns or the things that they agree upon. Now, I'm going to go out of line a little bit. We have three bills on the agenda, and two of them are not going to take that long. So what I'd like to do, if you'll bear with me, and if it's okay with our members, is I would like to go out of sequence and have House Bill 45 go ahead and come to the table with Representative Boland. And if you will, come to the table, Representative Boland, and have your guests identify themselves for our record, and I'll turn the mic over to you. Senator Schickel.
Thank you, Mr. Chairman. I just wanted to inform you that I have a committee sub on this bill.
Okay, we have a committee sub. Do we have a motion on the sub? Second. All those in favor, sign of aye. Aye. Opposed likewise. The motion on the committee sub is proved favorable. Representative Boland, is this a favorable sub? Is it a friendly?
This is a friendly sub. Thank you, Mr.
We
Chairman.
better ask now that it passed. Very good. I'll turn it over to you to speak on the sub.
All right. Thank you, Mr. Chairman. Adam Bowling, State Representative, 87th District, Bell and Harlan counties, and with me today are
Rebecca Hartsoe, Babbage co-founder.
And Rusty Kress here on behalf of the Kentucky Association of Manufacturers.
Mr. Chairman and members of the committee. Thank you for the opportunity to present House Bill 45 today. This piece of legislation I'm very excited about because it will help spur economic investment while also reducing plastic waste, a win-win opportunity we don't often see. This bill simply provides for transparent rules for a new type of technology that actually breaks plastic waste back into the molecules the plastic is composed of in a process we're calling advanced recycling. This process is more akin to a manufacturing process, so it defines these facilities as manufacturers rather than solid waste facility and establishes definitions for the types of technology that would be used in this process. We are already seeing big investments in other states that have passed similar legislation. For example, Eastman Chemical, just across the border in Tennessee, announced last January that it was investing $250 million into one of these facilities. The other benefit of this technology is that it is actually able to recycle plastics that typically wouldn't be recycled, like styrofoams and plastic wrappings. So we have created an additional recycling markets with this technology as well. Studies have estimated that if we can just capture 20% of the plastics in circulation in Kentucky through advanced recycling, that Kentucky could support 8 of these facilities, having an annual economic output of $78 million and keeping 360,000 tons of plastics out of our landfills each year. Last session, we heard this for information only in House Natural Resources Committee. The Energy Environment Cabinet requested that 2 minor changes be made to the bill, and those are incorporated in the current version. In addition, the Kentucky Resources Council and American Forest and Paper Association requested modifications, and those are reflected in the current version as well. Mr. Chairman, I'll wrap up by saying I think we have a really great opportunity here to give these companies the clarity they need to operate in Kentucky and bring investment into the Commonwealth while at the same time reducing plastic waste.
We also have a motion and second on the bill. We have Tom Fitzgerald and Q to speak. Tom, do you want to speak at this time?
Mr. Chairman, I'm fine. I think Representative Bowling has described the bill well. We are supportive of the bill and would encourage that you send it out with a favorable expression.
All right, so we have no further questions on this particular bill. Senator Schickel.
Thank you, Mr. Chairman. I just wanted to explain for people, maybe, there's more and more people watching these committee hearings on their computers at home. I know this from some of the questions I got, and sometimes these committee subs confuse people who are not familiar with the process. And being that I offered the committee sub, I just want to take one moment to explain what we did. What we did was the bill sponsor had a few it's basically the same bill, but the bill sponsor had a few minor changes, and they requested this committee sub. It's basically the same bill with just a few minor changes, and that's what we called the committee sub. I just wanted to share that with people that may not be familiar with it.
Thank you, Senator Schickel, and thank you for your help on the committee sub.
Okay, so we ask the clerk to call the roll at this time.
Senator Carpenter, Senator Caslin, Senator Embry, Senator Harper Angel, Senator Schickel, Senator Southworth,
Aye.
Senator Turner.
Explain my aye vote, Mr. Chairman.
Please go ahead.
Thank you, Mr. Chairman, and I appreciate you bringing this bill, Representative. It's important to mine in your area since we're representing in the same place, and I look forward to working with the industry to help move this along, because that garbage beside the roads every day, we see it everywhere, and I hope we can pick it up and get running real quick. Thank you.
Senator Webb, Senator Westerfield, Senator Wheeler,
Mr. Chairman, explain my aye vote.
Please go ahead.
Yeah, I'd like to concur with my friend, the senator from Harlan. I actually passed some legislation myself last session in an attempt to clean up Eastern Kentucky, and the fact that we can actually utilize some of the things we get to actually make some money and provide jobs in the community is a wonderful opportunity. So I want to thank the representative for bringing this bill.
Chair Smith.
And I vote aye, and I just explained my vote. You know, for several years, I've talked about in our sailing school that I do in the summer for children for free, just as a gift to our region, to encourage people to participate in water sports so you'll do a better job of taking care of it. But we talk to our kids about the 1.6 million square meters of the Pacific garbage patch, and that's mostly plastic. And people do not think about all the medical waste that's coming out, the syringes that we've had with the vaccine, and how it gets in Kentucky's waterways and makes its way to the Ohio River, and it contributes. This place used to be the size of Delaware, and now it's growing to the point that I'm not sure that that we have the resources available to clean it up. So what you're doing, it has a much bigger impact and positions Kentucky to be more responsible and how we handle waste in our state and what the waste from our state actually impacts everyone else. So I appreciate you taking this on, a tremendous piece of legislation. This motion approves the bill that the same shall pass as amended with the committee substitutes. So good luck to you as you begin to head to the floor. We have a motion for consent, a second. All those in favor of the sign of aye. Opposed likewise. The motion carries. We have you on consent. Representative Bolden, thank you.
Yeah. Thank you, Mr. Chairman. Thank you so much, committee.
Right, next, we will bring up House Bill 195. And as you all come to the table, go ahead and please identify yourself for our records.
Thank you, Mr. Chairman. Thank you, members of the committee. State Representative DJ Johnson, 13th District, Davis County, here to present House Bill 195, and I allow my other presenters to introduce themselves.
Good morning. Aaron Thompson, State Government and Community Relations Manager for TC Energy.
Bob Babbage, co-founder for TC Energy.
Thank you, Mr. Chairman. And we're working on a slide presentation, which is just a couple of slides, which apparently has worked. That's a good sign. But very quickly, I'm here to present House Bill 195, which is amended by House Floor Amendment 1. And 195 provides guidance for improved communications between property developers or property owners and interstate natural gas pipeline operators and liquid gas pipeline operators. Before getting into the specifics of the language, I need to provide just a little bit of background information. The Commonwealth of Kentucky has 6,532 miles of interstate natural gas transmission lines. To give you some idea of the extent of natural gas pipelines in the country and in Kentucky, let's take a look at a couple of slides. This gives you a picture of the entire country, just to get a feel for how many of our citizens are impacted by pipelines throughout the country. This shows some of the pipelines in Kentucky. And again, if you just think about looking at those pipelines, how many of our citizens live close to or work close to those pipelines? And this is in the central part of the state, to give you, again, just to bring it down a little closer. This is eastern Kentucky. Again, as you notice, they're literally impacting almost every citizen in Kentucky. And then finally, an area near and dear to my heart, this is actually the Owensboro area, and we have a strong interest in these pipelines. They literally cross all of Davis County. Pipelines have historically been intentionally routed away from larger cities in the regions, but close enough to serve those areas. With the tremendous growth and sprawl that we have seen over the past decades, pipelines are now consistently squeezed by houses and all types of commercial and other institutions and developments. Additionally, counties, cities, and smaller towns often don't have planning departments with the jurisdictional power to monitor and manage these territorial conflicts. And then finally, pipeline operators are required to meet stringent federal operation and maintenance standards, which can change as developments grow closer to the pipelines. As Kentucky's population and commercial development increases, these conflicts of interest also increase. When implemented, this bill will coordinate private sector collaborations through the planning and zoning process. This will help ensure pipeline operators are in compliance with federal standards, but more important, it'll maximize the safety for our Kentucky citizens. So how has this language been developed? This process actually started in 2010 when 130 stakeholders representing pipelines and community planners from across the United States joined with several federal government agencies, including agencies like the Department of Transportation, the Pipeline Hazardous Materials Safety Administration, and Office of Pipeline Safety, to come to an agreement on what the best practices are with regard to pipelines and development across the country. The procedures in House Bill 195 are based in large part upon the codifying of these different practices. What 195 does, and now we're getting into the details, getting into the actual meat. 195 requires developers to inform pipeline operators when initially coordinating with planning commissions of their plans for a new development near an existing pipeline. It directs planning commissions to notify a pipeline operator about the planned development of any residential or commercial building within 660 feet of the transmission pipeline, and to do so when a development plan is submitted to the planning commission. It requires developers to provide on the final plat of the regional planning commission a note that indicates that all reasonable means were used to obtain information about pipeline facilities and then review, or at least attempt to review, preliminary information about the proposed development with the pipeline operator. It instructs planning commissions to gather pipeline location information from the National Pipeline Mapping System within 60 days of the effective date of this legislation. And finally, it obligates pipeline operators in return to provide pipeline location information to developers upon notice of a preliminary development plan. All that to say this: it increases communications between developers and pipeline operators, and it encourages that communication to take place earlier in the development plans for any kind of potential development we have. As it stands, 57 of Kentucky's 120 counties have planning commissions. This bill affects only those 57 counties. Interstate pipelines that run through counties without planning commissions are in much more rural areas, and development near pipelines is far less likely. And on top of that, communications between developers and pipeline operators are more ongoing. Finally, what this bill does not do: it does not allow new exemptions related to the Underground Facility Damage Prevention Act or Kentucky 811. And it does not give planning commissions the authority to restrict developments because of pipeline locations. Pipeline operators understand that as development grows, their operational and maintenance requirements for their pipelines will change. They understand that, they accept that. This does not interfere with that development. What it does do is simply increase communications between developers and pipeline operators. Mr. Chairman, subject to any questions, I request passage of House Bill 195.
Thank you, Representative, for your presentation. We do have some questions. Senator Wheeler has a question.
Thank you, Mr. Chairman. I believe it may have been answered. So this is only going to apply in areas where essentially zoning regulations have been adopted, correct?
That is correct.
And I can recall of, it's probably been 15, 16 years ago, there was an explosion on a pipeline in Floyd County that I think was not in a zoned area, but it, took out several houses, I think. And I think thankfully nobody lost their life, but there was some folks that suffered some severe burns. So I can definitely see the need for this, and I think it seems like an adequate safety measure. So thank you for the bill.
Thank you.
Senator Caslett.
Representative Johnson, this question you might have to answer later. What size of a pipeline or length of it would it have to be considered a transmission pipeline?
Would you like to take that?
Yes, absolutely. So, Senator, basically anything that's an interstate line, so anything that is regulated by the federal government. So none of the state ones that would be regulated by the PSC, for example, would not apply. Just would be those federal pipelines that are oversaw by the federal government. And so that varies in size completely based upon the specifics. It could be a very small line, probably under 12-inch, but potentially larger than 40-inch as well, depending on the specifics of the line.
Okay, thank you for that. And Representative Johnson's presentation really helped. He understands how I feel sometimes about empowering planning and zoning offices, especially when it comes to developments and economic growth. And so I appreciate that.
Okay, any other further sorry, Senator Webb, I apologize.
Thank you, Representative Chloe Aaron. I was just wondering about the definition of development. Is it somewhere else, or what exactly does it have a definitional parameter?
You know, I've not heard that question yet. Bob, do you have anything?
Leave
on
it to
that?
me, DJ.
Yeah.
And I can speak to that a little bit, Senator. So basically, you know, if there, we're, as far as how we're regulated, there's basically class 1 to class 4, which determines how many people are within dwellings within 660 feet of a pipeline. So this would apply to anything, whether it be commercial or residential, because all of that would fall within the dwelling requirements, essentially, that the federal government puts on us.
So it would be any commercial enterprise, and could be a farm or
potentially
anything like that?
Potentially, you know, anything that has a dwelling with people on there. And so, for example, if we have a pipeline within the 660-foot corridor, which is really what this is targeted at, and the feet area that's laid out in the bill, if there is any increased activity there as far as increased numbers of dwellings, new buildings, et cetera, that's what actually triggers us to have to increase our class size, which is really what this is targeted at.
I was just trying to get clarification. If an entity, let's take an agriculture entity, would come in and purchase property and have agritourism, have a commercial component on farm or on site, whether or not it would apply to them.
Yeah, it's essentially, if there would be people that within there that would apply. So anything that has a dwelling, essentially.
Okay,
Yeah.
thank you, Mr. Chair.
And we have Senator Casson as a follow-up question.
Just to follow up, because Senator Webb sparked one more thing, and I'd say Senator Hornbeck, if he could ask this question, he probably would. So currently, right now, ag has an exemption from plan reviews and development plans whenever they do anything. Would this now, if there's a pipeline ran through somebody's farm, require them to go to the planning departments to have a development plan for like building of a shop or grain system or something?
I think that's something we might need to, you know, follow up on a little bit for sure. But really what I would say is that, you know, it really flows into what the current process is. So I would think that it maybe would not apply from my understanding, but it's based upon what we currently have in place as far as the planning commissions within the state to really fit within there and not create any type of new bureaucracy or anything like that. Basically just an additional box to be checked during the current planning commission process to make sure that the communication has occurred.
Yeah, the real purpose of this legislation is not to increase effort by anybody, but really it's more about the timing of those communications. So I wouldn't think there'd be any change to the existing regulations and rules based upon this legislation.
We have a motion and a second. We also have Tom Fitzgerald joining us, who's asked to speak. Tom, we'll turn it over to you. Tom, can you hear us?
Thank you, Mr. Chairman. I'll be uncharacteristically brief. I just want to thank the sponsor for the amendment that was made in the House that extends this to cover hazardous liquid pipelines as well as natural gas pipelines. The change makes it consistent with the federal recommendations that were developed by the consensus group that he mentioned, the pipeline group that included representatives of industry, landowners, and government, which is just trying to create a consultation zone, is what they call it, where if you're within 660 feet of a pipeline, you let the developer know. This is not intended to expand anything that requires local approval. So if it's exempt from local zoning and planning now, it stays exempt. This is simply where you have a development, residential or non-residential development that requires a development plan. Currently, that's where it would apply. And essentially, getting back to Senator Wheeler's point, up in Ivell in Floyd County, there was, I think, 6 houses ended up getting blown up, and a number of people went to the hospital. Thank God nobody was killed. But these accidents are rare. But when they happen, they have fairly catastrophic consequences. And what this intends to do is just to provide a heads up. There's nothing in here that prevents local communities with planning and zoning from going a step further and saying, we don't want developments that have a difficulty in evacuation from being placed in proximity to pipelines. Just common sense. And a lot of times people do the development, they never know that the pipeline is in close proximity. So it's a heads up, it's consultation. It doesn't have any mandate other than that. You might be surprised to know that there's nothing in federal law that prevents you from building a new pipeline right next door to a house. But that's for another day. This is dealing with existing pipelines and new development. And we are supportive and appreciative of the bill and appreciative that industry has stepped up and said that this needs to be part of Kentucky's law. Thank you, Mr. Chairman.
Very good. We have a motion and a second on the bill. I'd like to ask the clerk to call the roll.
Senator Carpenter, Senator Caslin,
I'd like to explain my aye vote. Representative Johnson is a near and dear friend of mine, and I think he has great intentions here, and I'm going to vote aye on this, but I would ask that you all look to make sure that this isn't going to affect anything that is exempt from current plan reviews and development plans going forward, because this could affect a lot of ag land. As you've seen there in Davis County and all over that map, there's a lot of pipelines that run through rural Kentucky to dodge a lot of the big cities, and the last thing I want to do is vote for something that now requires that. And so I know that's not the intention, but if you all can look into that, if we need to file an amendment to it, we can. Thank you.
Senator Embry, Senator Harper Angel, Senator Schickel, Senator Southworth,
Aye.
Senator Turner, Senator Webb.
I'm going to vote aye with the same concerns as my question, and if I can be convinced that it doesn't apply to agricultural land and enterprise, and I would join with Senator Caslin in filing a floor amendment if it does.
Senator Westerfield, Senator Wheeler, Chair Smith.
I cast an aye vote. Senator Carpenter, do you want to cast an aye vote? The motion is approved that the same shall pass. Thank you, gentlemen, for your time, and look forward to seeing further follow-up on the floor.
Thank you, Mr. Chairman.
At this time, I'd like to ask our guest from the carryover from our previous meeting on Senate Bill 69 to go ahead and come to the table. David, if you would, please have your guests identify themselves for the record. And again, a sincere apology about running out of time at the last meeting, but we reserved the remainder of our time here to let you all be able to finish your thought. And we appreciate the travel and all the juggling that took place for you guys to renegotiate coming back in front of this committee. And so I'll waste no more time and turn it directly over to you.
Sure. Thank you. Thank you, Mr. Chairman. And, I will tell you that my father, who's a retired preacher, got a little bit of a kick out of it. He told me, son, your sermon ran long and your audience ran early last week. So so try to avoid that today. I'll let Ms. Jensen introduce herself.
Hi, my name is Lena Jensen, and I'm an engineer working with NextEra Energy Resources.
Hi, Jenna DiValerio with NextEra Energy Resources. I'm a senior manager of regulatory and political affairs. And it's a pleasure to see you all again.
Welcome to our committee.
Yeah, and again, thank you. I think most of the members were here, but maybe for those who are not last week, just to introduce myself, I'm David Sanford with the law firm of Goss Sanford PLLC. Over the course of my career, I've had the opportunity to see this solar issue really from just about every perspective. I represent developers who bring these projects to fruition. I also represent public utilities who purchase the power to be able to deliver to customers and industry and meet economic development needs. I've also represented landowners who've entered into negotiations and leases with various solar developers for their use of their land. And then I also served previously for a period of about 5 years as general counsel of the siting board. So this is, again, as I said last week, this is an issue that's very complex. It's very technical. When you make a change in one area of the law, it's very easy for there to be unintended consequences in other areas of the law. And it's our goal to be able to avoid that and to keep that risk to a minimum. The purpose of the siting board has historically been to be a backstop for instances where there is no local siting considerations or agency in place with jurisdiction to be able to make these kinds of decisions. The flaws in the current law are that there's really nothing in the statute right now that addresses decommissioning of these projects, which we agree that there should be. But one that's even more significant, perhaps, is that there's no way to resolve conflicts between state government and local government mandates. And what we see on projects is that that becomes increasingly more likely. And I fear that by having a more state government-oriented approach with regard to Senate Bill 69, that we actually make that risk for regulatory risk more systemic and make those types of conflicts more likely to occur. There were a couple of things that came up in last week's hearing that I just want to address. One of the purposes was stated was to keep home rule as much as we can, but there's really nothing in Senate Bill 69 that promotes home rule. The only provision where there is home rule currently for the siting or for local jurisdictions is with regard to setbacks, and that doesn't change here. So there's nothing that promotes or encourages home rule. There's another bill that's before you that's House Bill 392 that passed by a vote of 91-3 a few weeks ago in the House on solar legislation that has a very clear primacy provision that makes sure that home rule is very much protected. There was also, I think, a question from perhaps Senator Southworth about the need for an emergency clause. And just to give you kind of an idea of where things stand, over the past 2 years, 29 notices of intent have been filed by applicants before the siting board. 22 applications have been heard. One of those was withdrawn. 18 of those cases have already been decided, and so the siting board's role is largely done there. One application scheduled to be decided next month. 2 are scheduled to be decided by August. So there's really not an emergent need for this legislation. The wave is already passed. There's only really, I think, 3 cases that are before the siting board now, and even with an emergency clause, I don't know that it would have any impact upon those decisions. So last week there were 5 different deficiencies that were noted by the supporters of the bill in the course of the meeting. One is there's a not a clean handoff between jurisdiction between the siting board and the Energy and Environment Cabinet. 2 is questions concerning the transfer of control requirements, which are not real clear whether that applies to before a project is completed or whether it's after the project enters its operational phase. And I can tell you that that is one of the most important pieces of this to get right, because it's going to affect every developer's ability to finance their projects. So that needs to be very clear what the intent there is. There's also a provision noted about giving the cabinet the ability to suspend operations, hugely problematic for 7 or 8 reasons. Most of which I was able to talk about a little bit last time. But it's also duplicative decommissioning bond requirements continue to be allowed. So what you may end up with a local obligation may be different than what you end up with a state obligation. And so, it's good that there be a decommissioning requirement, a decommissioning bond, a decommissioning obligation, but they should be consistent with each other. And then also, as late as yesterday when I spoke to some of the folks with public utilities, they still have the same concerns that were expressed last week about how the site assessment report accidentally causes them to have additional issues on the regulated side of their business and how they'll be able to interface with the Public Service Commission. So in addition to those 5 things that were noted last week by supporters of the bill, I also want to point out some other things that were not mentioned or that we didn't have really a good chance to discuss. One of them is in Section 7, subsection 3, Part B of the bill, which is really what I would describe as a false promise. We go through the elaborate exercise of requiring decommissioning bonds and having those set by independent parties. But at the end of the day, when you name a local government or EEC, the bill says that they have no responsibility to actually follow through on the decommissioning obligation. So what's the point of naming a local government or state government as a beneficiary on a decommissioning bond and then making it subject to their discretion 20 or 30 years down the road as to whether or not they'll actually follow through on that commitment? From a landowner's perspective, that means this bill is effectively worthless. There's not really a protection that's afforded by having a government agency be the beneficiary of a decommissioning bond if they can choose in the future that they're not going to follow through on that obligation. And so that's a major problem with this. If I was talking to a landowner and representing them, I'd say, you cannot be in favor of this legislation for that reason. Another area is it greatly expands EEC jurisdiction, and I think that there's a problem there. Section 6, subsection 6, Section 7, subsection 4, Section 9 subsection 3 are all grants of authority to the Energy and Environment Cabinet. But rather than just say you've got the limited authority to make sure that that a bond is filed, that it's regularly updated, that notifications are given when transfers of control take place during the operational phase, it gives the agency, the cabinet, jurisdiction to enforce the conditions of the siting board's orders. And I've never seen a place in statute where an agency's jurisdiction is defined by the orders of another agency. I think that there's a constitutional delegation of powers issue there, that one agency of state government's authority can be expanded or contracted by the orders of another one. That's definitely an issue that should be looked at, because it's not clear, and from a developer's point of view, it creates risk because you don't know what the scope of the cabinet's jurisdiction is going to be until you actually receive the siting board's order. Again, as I said earlier, there's no way to resolve what happens if you get inconsistent obligations imposed by a local government agency as opposed to the siting board, and that creates a lot of risk for developers, for financiers who are just going to take their investment and go somewhere else where you don't have that problem. There needs to be a very clear primacy kind of provision to make it clear whether it's state government or whether or not it's the local agency, it's going to have primacy with regard to these decisions. Again, historically speaking, it's always been the siting board's role has been to be the backstop to existing or the absence rather of local jurisdiction. And so this bill moves away from that. It really turns it on its head by making it more of a state-centric as opposed to a local-centric issue. In Section 7, subsection 3, subpart A, we're talking about the formula, if you will, for setting the decommissioning bond. I think the attorneys on the committee will appreciate this. There's language in there that says the bond must be set by the siting board that's an amount that is at least what the independent engineer would say. Typically speaking, administrative agencies are required to act upon the evidence before them, and so what the evidence demonstrates is not the floor for them to go ahead and then take action. That is what their decision is supposed to be based on. But by saying that the bond has to be at least what the evidence supports, but it could be higher, you're inviting arbitrary and capricious decisions by saying that the evidence is only somewhat relevant. We're going to allow you to go beyond that. So that's problematic. In Section 7, subsection 1, subpart J, we have a public interest standard that's introduced into the siting board for the very first time. And what it really does is it elevates the significance of the decommissioning plan over and above the other considerations. If you look at that statute, what it does is it has a list of criteria that the siting board is supposed to take into account, but no one criteria is any more significant than the other. They're all to be weighed. The siting board's to look at the totality of the circumstances and then render its decision. Here, however, what we're doing is we're saying in this bill that a public interest standard should apply. Now, the irony of that is that there is no public interest standard anywhere else in the siting board statute, and what you're doing is you're making the interest of the landowner very servient to some amorphous greater good community standard, which I think from a protection of individual property rights, that there's should be some attention given to that, as it very fundamentally alters the ability of a person to be able to do with their property, as opposed to some other use. Under this bill, it would be perfectly okay to put in a pig farm right next to a residential neighborhood, but I couldn't put in a solar facility without going through a bunch of extra hoops. Whereas, it doesn't quite make sense. In Section 4, subsection 2, and then Part A of that, we have some exceptions to the setback requirements that are included in the statutes, and there's an element of unfairness here because we have statutory setback requirements which will apply, which I think are a good thing. But what we also have is an exception for that. So if you're a Kentuckian that happens to live in proximity to a Superfund site, a reclaimed mine land, a brownfield, you don't have the authority or the ability to challenge the setback requirements that are being proposed, because this bill takes that right away from you by saying that the setback requirements in the statute don't apply. And that's a fundamental issue of fairness. The siting board has the ability under existing law to be able to grant deviations on a case-by-case basis based upon the circumstances of each application, and that should be allowed to prevail. There shouldn't be certain land uses that a setback statutory requirement doesn't apply, because that's very unfair to the people who live next to them. Another thing that's not in the bill, which is a key feature of House Bill 392, and again from the landowner's perspective, the key parts of the decommissioning plan in House Bill 392 are required to be incorporated into the leases. We don't have that provision here, and let me explain why that's an important part of the House legislation, is because everything in Senate Bill 69 really is requiring the state government to come in, to step in, and to remediate any sort of default on the part of a developer at some point in the future. Under the approach in the House bill, that's still true, that the state can still do that, but you're also, by matter of contract law, you're giving the landowners the ability to have these basic protections written into their lease agreements. They're required to be an element of the statute so that they can enforce their own rights as a matter of contract law. And I would submit to you that that is a better protection from landowners rather than waiting for state government or local government to possibly act in the future. Just a couple of more. The venue in Senate Bill 69 is a deviation from the way that it currently works. Currently, all decisions that are made by the siting board are heard, any appeal from there are heard in the circuit court in which the project is located. Here, what we'll have under existing law, any appeals from EEC decisions will be heard in Franklin Circuit Court. So developers, local government, interveners are now going to be subject to venue in two different circuit courts. And then there's also additional fee language in Section 8, Section 8, subsection 1. I don't know if people realize really the magnitude of the siting board's application fees, but it's generally at least a $40,000 filing fee. That's the minimum. It can go up to $200,000. When you had a transmission line on top of that, it's not unheard of for a siting board application fee to be approximately $250,000. Over the past 2 years, I think the siting board has received about $2.3 million in siting board fees. That's all fine. That's appropriate for making sure that those cases are able to be processed. But when we're adding new fees that are to be paid over the lifetime of a project, it's important to take into account really what's the basis for that. And they should be transparent, but they should also really be based on what are the costs of the service. It should be a one-time fee that covers the entire useful life of the project. So those are the highlights. There's a few more I could cover, but in the interest of time, we'd be happy to address any questions, Mr. Chairman.
Okay, do we have members that have any specific questions? Senator Southwood.
Thank you for all of the details, and I've enjoyed your preview from the last meeting and this meeting as well. And you mentioned House Bill 392 last time, and you mentioned it again today with a couple of things that were not in our bill. Is House Bill 392 essentially our bill plus these things, or is it totally different and so we really need a mix?
I think there is a different philosophy in the two bills. Senate Bill 69 is really premised, in my opinion, around the idea that it will be up to the state to solve the decommissioning problem. And so all of the decommissioning obligations, responsibilities, everything related to that will be driven by either the siting board, the Energy Environment Cabinet. House Bill 392, I think, is more reflective of where the siting board statute has been historically, that we're going to allow local governments to impose their own decommissioning obligations. They already can do their own setback requirements. But in situations where that local regulation does not exist, then House Bill 392 provides a state-level uniform framework. So it's more of a safety net. The safety net's a good way to think about this, because right now under 392 you have kind of a statewide siting board jurisdiction, the EEC jurisdiction approach, whereas under 392 where you really start is the contractual promises that a landowner is required to receive as part of their lease. Then you have the opportunity for local governments to be able to provide a safety net to that. And in the absence of that, then there's another safety net, which is the state obligations. So that's why, from our perspective, that would be a preferable piece of legislation.
Okay, thank you.
Senator Webb.
Do local governments, I mean, you know, local governments is a pretty broad term that encompasses a lot of different sizes and capacity. So when I'm sitting here thinking about some of the local governments, you know, what's the safety net that those entities have the expertise and the ability to provide that safety net even at that first level?
Well, I appreciate the question, but what I can tell you from experience is that they've gotten up to speed on this relatively quickly. In the counties where I've seen several projects, and I can't speak for all counties or all projects, but there are a lot of local ordinances that have already been adopted that address decommissioning. And to a fair degree, they're all fairly uniform. There may be little nuances here or there. We've also had conversations with CAECO, and I know that they were supportive of 392 and the League of Cities as well. And I would anticipate, you know, as legislation rolls out, whatever it may be, that I would think that they would probably help their members be able to develop best practices. So I hear your concern, but I don't think in practice on the ground it's as big of a concern perhaps as you might think.
Very good. Tom Fitzgerald. Tom, do you have comments at this time that you want to add to the discussion?
Mr. Chairman, thank you. We're running short on time, so I'll try to be very brief. I could not disagree more fundamentally with a number of the concerns that David has identified. House Bill 392 is not in front of the committee today, but I would just say, since it's been talked about significantly, that House Bill 392 is very pro-developer and very anti-landowner. And we have grave concerns regarding the fact that it requires a bond be posted but doesn't allow anybody to review the adequacy of the bond. It provides that the provisions of state law shall be incorporated into the leases, and it prevents a landowner from requiring that all of the components of a solar system be removed at the end of the facility's life. We think that that's something the landowner should control rather than having it be dictated by state law. The developer certainly would like to leave some of the heavy, big pieces behind, but we believe that the Senate bill is much preferable in providing that those pieces are removed unless they're going to continue to be used. There are some minor technical glitches that stand to be fixed, and regarding the relationship of the certificate that utilities get and the siting board, it's a very easy technical glitch that Ms. Chairman, you had identified at the last meeting, is very easily rectified. Certainly was unintended, but for the most part, the idea that you would delegate to an engineer who's employed by the company the determination of what a bond adequacy is not appropriate. We don't do that in any other regulatory scheme. I didn't have the benefit of being on the siting board. I certainly participated in the writing of the statute, and the statute, as has been mentioned, has worked fairly well. We've had a number of existing developments, new developments that have already been approved that require decommissioning bonds that have protections in them regarding setbacks. And so the idea that we have a board that's dysfunctional and is in need of significant reform is simply not the case. There has not been the conflict between state and local communities. And the idea that this was intended to be a backstop rather than to be an exercise in cooperative regulation is simply not the case. This was intended to provide a comparable process to that occurs for utilities in terms of siting. It has functioned well, although there are things that need to be tightened up. And that's what Senate Bill 69 was about. So without belaboring the issue, there are endless debates among attorneys regarding what a particular phrase might mean or how it could be construed in the extreme. But Senate Bill 69, subject to some technical revisions, is a good, solid piece of work that has been a consensus product for everybody except the company that is testifying before you. There are still things that can be done to make it a better bill. But there are a number of suggestions here. The suggestion, for example, that the board is incapable of weighing evidence other than that provided by an engineer employed by the company in determining what the bond amount should be. That doesn't mean they're arbitrary. That means they're doing their job. So, if we had endless time, we could talk endlessly about interpretations or extreme interpretations of what the law requires. I think it's a good bill, and I would encourage the committee's consideration. Obviously, as Senator Hornback has indicated, there will be additional changes that will be made to make it a better bill, and I would just encourage your support. Senator Hornback has done yeoman's work carrying this bill, being very patient, being very open to changes from all quarters. And I appreciate him having done this. Thank you, Mr. Chairman. Happy to answer any questions regarding any of the details that were raised by the current witnesses or anything else for that matter on Senate Bill 69.
Very good, Tom. Thank you. We have one last question from Senator Wheeler. Senator Wheeler, please go ahead.
Yeah, briefly, and it kind of follows up a little bit on the question by Senator Webb. I mean, and I guess it's more of a comment with a question at the end. I mean, I have seen some small municipalities that perhaps have not made the best decisions, especially in depressed rural areas where, they're looking to land a development and are willing to kind of go out on a limb and possibly play fast and loose with some requirements in order to get them to come to a particular location. And then, once it's there and the party's over, and if you're left with a mess, they may or may not have done their due diligence on the front end. The county officials or local officials are long dead or voted out of office, and there's really nobody to hold accountable. And I guess with that obligation in such a circumstance, I mean, would it be fair to assume that back on the state and the taxpayers if that happened?
Well, I'm not sure let me make sure I understand your question. The way that Senate Bill 69 works currently with the committee substitute, there is no state government or local government agency that has any responsibility to follow through on any decommissioning obligation, even though they're named as a beneficiary of the bond. So the problem that I think you're trying to remedy isn't remedied by this piece of legislation in its current form. Could it be fixed? I think so. If a local government has a decommissioning obligation in a fiscal court ordinance, in a planning and zoning regulation, in a conditional use permit that's issued by a board of adjustments, they obviously have a little bit more skin in the game because it's their own order that they're enforcing, it's their own rules, their own regulation. So I think it's reasonable to assume that a local ordinance that has a local requirement is more likely to be enforced, which is again the premise of House Bill 392, than this piece of legislation, what leaves it to the discretion of future decision makers who may no longer be there. So I don't know if that answers your question. The one thing I would say is I remember distinctly Chairman Meredith asking Mr. Fitzgerald at the conclusion of the House committee where 392 was voted upon unanimously, I think. And he was asked if he supported the legislation. He said it was a good bill then. So he may have forgot that, but I remember that question being asked very distinctly.
Mr. Chairman, can I respond very briefly?
Very briefly, yes.
That is inaccurate. I did not talk to the committee in the House because I wasn't able to get up with Representative Meredith before the committee. And so as a matter of courtesy, I had not talked to an extent about the committee. The House Bill 392, we have written material that we sent out. It has significant problems. I wasn't about to embarrass the sponsor of the bill in front of the House committee, but that is a misstatement of our position, and it has always been our position. House Bill 392 is very pro-developer and is not pro-landowner. I'd be happy to go through each section at the committee's leisure.
Very good. Folks, here's where we're at. We've had a motion and a second on this bill, and that bill was voted out of our committee. The chairman has very honorably been willing to work on some floor amendments. I think he's verbally said there was a few things that were unintentional and that he wants to address. What I think will happen here is there'll probably be a follow-up group where we sit down with Senator Hornback and the parties that are interested, and we will be able to work on what we're going to look at as far as a possible floor amendment. So I encourage you to just stay engaged with us. If you'd like to do that through me directly, and then I could reach out and coordinate with the Senator Hornback and all interested parties. But as this goes forward, obviously we want input. There's going to be time for input to be put in. We've got some time to be thoughtful about what we want to do. And this is a very, very big bill. It's an important bill. So we appreciate your time today for your testimony. And at this time, if I